Parliament has been holding public hearings in various provinces on the land expropriation bill. The bill is aimed at providing the mechanisms for and the circumstances under which land may be expropriated with or without compensation as envisaged by Section 25 of the Constitution. To unpack the bill and the current processes that are undergoing, I'm joined by the chairperson of the Ad Hoc Committee on Land Expropriation, Dr. Matola Motshekga, to be a part of the conversation. You tonight are joining us on Twitter at Newzroom 405, or you're sending us your WhatsApp questions and your comments to 072-110-5584. Advocate Motshekga, good evening and thank you very much for your time.
Good evening to you and to the listeners.
We are, of course, talking to you right now. And as far as the process is concerned, as of tomorrow or so, you will have about 30 to 31 days for this particular process to be completed, as the deadline is set for the end of May. What is the likelihood that the draft bill will be passed in its present form, or the likelihood that it will be amended, and the likelihood that it will not pass at all?
Firstly, let me thank all the members of the Ad Hoc Committee from different political parties for the cooperation that they've shown amongst themselves and between themselves and the chairperson, and their realization that we are not dealing with a party political matter, but a South African matter, and we are looking for a South African solution. You will know that the Section 25 is part of the, whatever we do must reflect the will of the people of South Africa as a whole, both black and white. And that's why we ensured that since we started, we never had to use voting, because we believe this is not a question of votes, it's a question of consensus. And we made sure that at the beginning, when it was difficult, sit with us, we listened to all of them, and we adopted a draft bill. But that draft bill did not really, it was a compromise draft bill, which did not necessarily reflect the positions of different parties on the matter. And but we needed that draft bill so that we could kickstart the process. And the process began, and there were complaints that we advertised the bill during the festive period, and there were calls that we should extend the time. We did extend the time, and we got written submissions. And then we then started the public hearings. Then we were interrupted by the outbreak of the COVID-19 pandemic, and with the result that the lifespan of the committee expired, and then the committee had to be re-established, and then we went back. I'm pleased to say that through the cooperation of all political parties and the public in general, we were able to conclude the public hearings, and we then engaged with the report of the public hearings, and finally we also adopted that report without any dissension, I mean unanimously. Now we have reached a stage when we can move now to so the question that was gazetted, because our democracy is both representative and participatory. So the bill that we gazetted reflects what the political parties, to a limited extent, thought about the matter.
Yeah.
But the people matter most.
Right.
And that's why we went out for public hearings.
So let's talk about that very same point of the people matter most. When we are talking about the desirability and the need to amend the Constitution, as you correctly mentioned, Parliamentary Committee was put together to investigate whether our Constitution indeed should be amended. Now, the report of the Joint Constitution Review Committee reflected that there were 449,000 valid submissions. 65% thereof voted not to change the Constitution. Yet you still went ahead with this new process now and the draft bill and wanting to change. Is there a particular rationale as to why you looked at that report and you thought we're going to go ahead anyway?
I don't know where that conclusion comes from, that 65% said no. Because the reason why Parliament established the ad hoc committee was because the majority of the people consulted by the Constitutional Review Committee said yes, it is desirable to amend the Constitution. On the basis of that desirability, the Parliament established the ad hoc committee. So Parliament did not go against the will of the people as reflected in the report of the Constitutional Review Committee.
Are we likely to then get another version of the bill? Is that what you're saying from the process that now you have embarked on with this draft bill?
Certainly, because as I say, the first bill was produced by public representatives, but our democracy is representative and participatory. So we adopted the bill before public participation, and we have to take into account the outcome of public participation, because the final bill must reflect the will of the people.
Right. Is there anything that could be said about the timing of the releasing or the publishing of this bill? The draft bill itself published around December. The Expropriation Act bill also published around the same time. There are those who are saying you can infer from this pattern of the timing that government is attempting to sneak through the amendment. Is that fair criticism?
No, government is not involved in this matter. This is a parliamentary process. It's not influenced by government or any other party. It is a parliamentary process, and it is conducted according to the consensus reached by all political parties in parliament. And the fact that the coincidence that things happen towards the end of the year, that is dictated by the program of parliament, because parliament does not only exist for this process. There are many other processes going on in parliament. So the slot that we found happened to be towards the end of the year.
Now, there are other processes, of course, that are going on, including the release of this document called the Beneficiary Selection and Land Allocation Policy. What is the role of that document in this process?
You must understand that with respect, we have different portfolio committees. For instance, we have a portfolio committee on public works, which is dealing with the Expropriation Act of 1975, and they seek to amend that. And there's a portfolio committee on land and agriculture. They are dealing with various processes on land reform generally. So our process doesn't stop those processes. And some of the processes are also very important, like the amendment of the Expropriation Act of 1975, because it is what the Constitution calls a law of general application, and which will give effect to the amendment that we seek to effect. So these matters are related.
All right. Let's look then at the preamble of the draft bill. I mean, they say the preamble is used to to interpret the contents of the bill. And if we look at it from what it says, whereas Section 25 of the Constitution of the Republic of South Africa in 1996 must be amended to make explicit that which is implicit therein, so that an amount of nil compensation is explicitly stated as a legitimate point for land reform. Make explicit that which is implicit. Is this amendment made simply to make the dispossessed believe that government, or let's say the lawmakers, are doing something? Or is there a requirement, really, a legal requirement for this to be done?
You see, our mandate by Parliament was to say it is implicitly that expropriation of land without compensation is permissible, but that this is not explicit, and therefore go and make that which is implicit explicit. That is the mandate that we received from Parliament. But now we also wanted to hear what the public is saying on that matter. So the public has expressed itself as to how we can make what is implicit explicit. And of course, there are divergent views because we are a multi-party democracy, and we have a vibrant civil society, and we listened to all of them, and we said we are going to attach equal weight to all the submissions, and that's what we are going to do, so that our conclusions should be fully informed by the will of the people.
Yeah, I mean, as a legal practitioner yourself, advocate, I mean, would you say the amendment was necessary for legal processes, or we were simply messing up with the supreme law of the country to simply reinforce a particular political rhetoric?
It was absolutely necessary because, you know, if you put 100 lawyers under one roof and ask for an opinion on a single question, you may come out with 100 different opinions. Now, if the Constitution is implicit, it means that different lawyers, even judges, can come to different conclusions. So if you make it explicit, you create legal certainty so that the meaning of the Constitution and the law should be accessible even to so-called ordinary people, because the law is meant by the people. It should not be something that should be understood by lawyers. It must be understood by all people that are subject to the Constitution.
As chairperson of the Ad Hoc Committee on Land Expropriation, Dr. Mathole Motshekga is staying with us, and we'll continue with this conversation with the co-chairperson of the Ad Hoc Committee on Land Expropriation, Dr. Mathole Motshekga. And we are, of course, talking the amendment to Section 25. It's the 18th Amendment Bill of this democratic South Africa. And what does it really mean, and what are the legal implications thereof? I'll get your thoughts in a moment on what your views are. But let's get back to the doctor. Dr. Motshekga, what does then, having gone through the process, you've collected your report, and you're saying there was this consensus amongst all political parties to adopt that report. What will that represent in as far as, for example, what already existed in Section 25? Is this amendment going to be limiting? Is it going to be entrenching? Or is it going to be furthering that which already exists?
We adopted the report, as I said, unanimously. And that report is going to serve as a source document in the debates that will ensue. But we deliberately created space until the 3rd of May for members of the Ad Hoc Committee to go back to their principals, that is their political parties, to seek further mandates, so that when they come back after the 3rd of May, there is no going back to consult with principals. They will make inputs informed by their mandates, and then we will engage with all inputs and work towards a consensus on the text, so that those mandates will help us to reshape the bill and make sure that by the 21st of May, we have a new bill informed by a consensus.
Yeah. So you are still, in my understanding, going to be tackling the text. Do you think there needs to be some amendments made to the preamble so that it captures exactly what you want to talk about? I'll tell you why. For example, look at this part of the preamble and tell me what your thoughts are on it, especially around the question of land hunger and what it actually means. Where else there is a need for urgent and accelerated land reform in order to address the injustices of the past that were inflicted on the majority of South Africans, especially as the hunger for land amongst the dispossessed is palpable, and the dispossessed rather are of the view that very little is being done to redress the skewed land ownership pattern. Has research been done to determine the degree of land hunger and what type of land people are hungry for?
There are land audits, which one produced by the Department of Public Works, another one by Department of Land and Rural Development, and those land audits are available. But even without those land audits, one has to bear in mind that when the 1913 Land Act was adopted, it was really to consolidate the massive land disposition which took place before 1910. And in 1913, the African majority had only 7% of the total surface of South Africa and its natural resources. And because of overcrowding resulting from that, the percentage was increased to 13% in 1936 after the Beaufort Commission. So you can see that regardless of what the land is needed for, there is simply massive special injustice which must be addressed. And you can address that when you have a constitution that does not provide legal certainty, which is open to different interpretations. And that's why our law reform process was slow, because there are things which were not clear. So we think that after this amendment, the law reform process generally will move fast and speedily.
So the land reform process painstakingly slow, and I think there is general agreement around that particular fact. But there is a feeling elsewhere. I don't know if you've got that same feeling as you were doing the rounds around the country, that people in South Africa would rather prefer to be given money. They feel that gives them a little bit more opportunity than land. So they are more interested in wealth creation than it is the actual land parcel itself. Is that a true thing? I mean, did you find that is the feeling as you were going around?
No, there are some people who felt that they need money, but because we have not educated our people sufficiently, that land is not about your need, my need, those of us who are alive today. Land is a resource for future generations. Now, if money was to be given to you and I, and we go and buy big cars and build big houses, and then we live the rest of the people landless, the future generations landless. So that cannot be the position, and actually it's not the position which was advanced by the majority of the people. The majority say we want land, we want to work the land, we want land for housing, we want land for development. So we are fully mandated to, amend the constitution to make the land available to the majority that was forcibly dispossessed of it.
Right. So you mentioned land for agriculture, land for living, land for conducting business, and so on and so forth. Is this text, the next text, limiting as far as that is concerned? Because it says amendments will further ensure equitable access to land and will further empower the majority of South Africans to be productive participants in ownership, food security, and agricultural reforms programs. Does that say you're only targeting farmlands in interpretation? What is the feeling of the lawmakers on that?
No, we're not targeting only farmland. We want to redistribute the land, restitute the land, provide security of tenure. So our approach is holistic. So in amending the constitution, will make sure that we take into the redistribution the need for land tenure, security of land tenure.
So are you saying that text would probably be amended or changed to include, as you mentioned, there are various other forms of land reform, restitution, redistribution, as well as security of tenure? Should that be explicitly mentioned there in that preamble?
No, you see, that text was a compromise text to make sure that we kickstart the process. So it should not be seen as something cast in stone, because the final text will be informed by the outcome of the public hearings and the discussion amongst political parties based on the mandates that they've received. But all political parties will also have to be guided by what the people have said, because a constitution must reflect the will of the people, not the will of public representatives.
Right. We've already mentioned, of course, that there are other processes that are ongoing, including the processes around the Expropriation Act, and that being handled by the Department of Public Works. And, of course, we've got the Department of Agriculture handling other processes as well. Did you feel there was a need for this committee, for example, to tackle what constitutes land reform, and what kinds of properties are we talking about here that will be affected by this amendment?
You know, it is not in our interest to duplicate processes. And that's why, for instance, in Parliament, we invited the Minister of Land Affairs and Agriculture, Honorable Togo Didiza. We invited the Minister of Minerals and Energy, Honorable Gwede Mantashe. We invited Honorable Ronald Lamula from Justice, who deals with the Land Claims Court. We invited Honorable Patricia Dilil to come and make their inputs and also address questions of overlap, so that we don't go and start afresh. And their inputs were very, very helpful, so that as we move forward, we are confident that we have taken everybody and everything on board.
Dr. Batolo Mutsecha stays with us as we continue. Next, we'll talk to issues of nil compensation or expropriation without compensation, and whether or not the bill ought to explicitly never interpret without compensation as meaning that the right to just and equitable compensation is removed. Welcome back to the Newsfeed Late Night with the co-chairperson of the Ad Hoc Committee on Land Expropriation. They are, of course, coming closer to the process of finalizing the draft bill on the amendments to Section 25. We're coming to your views in a moment at Newsroom 405. WhatsApp your questions and your comments to 072-110-5584. Dr. Batolo Mutsecha still with us. We wanted to talk the question of compensation. Now, the preamble on compensation says the Constitution of the Republic of South Africa 1996 must be amended so as to provide that that where land and any improvements thereon are expropriated for the purposes of land reform, the amount of compensation payable may be nil, and to provide for matters connected therewith. Let's talk about that nil compensation. There are some who are saying it has to stay nil, and nil does not mean without compensation, and there ought to never be an interpretation of nil compensation to mean that right to just and equitable compensation is removed. You agree with that?
That's why we had to put these matters before the people, because others say, if you say with nil compensation, is a way of running away from without compensation. So we have these options before us, and these are the options that are going to be debated in the ad hoc committee when we reconvene after the 3rd, and we will be open to persuasion one way or the other. So I cannot express my opinion on that, because as chairperson and guide the process to consensus on these issues.
Right. The other part of that I wanted to just get clarity on is the question of improvements of land, because it says there where land and any improvements thereon are expropriated for the purposes of land reform. What does improvement really mean in this context? Does it include the movable assets that are on the land? Because that's one of the issues that I suppose many people are complaining about, and other parties are even campaigning about, to say when this bill goes through, they'll even be able to take, for example, tractors on the land, if you're talking about agricultural land, and any other implements and water rights and so on and so forth.
You see, water is a public good. If you get land, you don't get water, the land would be useless. And that's why the question of water rights cannot be separated from the question of land. But when it comes to improvements, that matter is also has been sharply raised, and it will be debated on. We're expecting political parties to come with their inputs as to what do they include under improvements, and how should these improvements be dealt with. And these are the matters that we cannot sit here and prejudge, because we will be usurping the rights of the political parties to debate these issues.
Right. And then let's talk about other issues then that are coming out of there. Does the proviso that the courts may determine or limit the amount, or the just and equitable amount that is payable, does that limit the state from doing that? Because I mean, it's already implicit in the Constitution that the state, where there is disagreement around the expropriation figure, they can serve an expropriation notice at nil. Does the fact that now the draft bill mentions that the courts need to determine the just and equitable compensation remove that power from the state?
We have, three spheres of government which are independent from each other. We are saying the question of expropriation is a process which must be led by the executive. But we have no right to deprive the courts of their jurisdiction. But we are saying the courts cannot be the ones that conduct the expropriation process. But where there are aggrieved parties, they should be free to approach the courts and say, I'm aggrieved. And the courts then will listen to them. But otherwise, the responsibility rests with the executive in implementing.
All right, Dr. Matola, are you still there? Hopefully your line is still connected. All right,
I'm here.
You're still there. All right, let's talk about the use of the word dispossessed to mean that it excludes other forms of land reform. It only speaks to restitution, but also what is in the draft bill that will protect against arbitrary dispossession?
You see, the 1913 cut-off date, or Section 25(7), deals with restitution, and we have recognized that. So restitution remains part of the process. But we are saying Section 25(8) deals with the redistribution. Because if you rely on restitution alone, you will not give full effect to the land reform process. So we will use the restitution process and redistribution process, which are governed by two different sections. And then we will also deal with the question of security of tenure.
And what is there then to guarantee, for example, a dissatisfied landowner that they can't just be arbitrarily kicked out of their land if they reject the offer to compensation?
No, you see, the reason that we are amending the Constitution and we are also passing the expropriation bill is to ensure that everything happens according to the Constitution and the enabling legislation, which is the expropriation bill. So we can't leave anything to chance, because we are a constitutional state that is governed by the rule of law and the Bill of Rights, so nothing will be done arbitrarily.
All right, let's have a look at some of the WhatsApp questions that have come through tonight for Dr. Matola Motshekga. This one is from Masibonge in Mabopane, saying land expropriation needs to be handed over to an independent body which is not political. Otherwise, land expropriation will just be like SOEs and become a theater for looting by politicians while the landless are watching. Dr. Motshekga, just that particular question, I mean, once you are done with your process, what is the body that is going to be responsible for then implementation?
The executive will be responsible. If you start saying a non-political party, you want to establish a parallel government which will need resources, and it's just not, doesn't make, with respect, good sense, because we have full confidence in the executive to acquit themselves in these matters. But we realize that there were certain legal and constitutional impediments, and as soon as we remove those impediments, We have no doubt that, capable men and women have been tasked to deal with these matters, and they will deal with them to the satisfaction of all concerned.
More of your WhatsApps tonight. This one from Lutendo saying, I'd like to ask ask what are the chances of AfriForum and those who are not in favor of land expropriation with nil compensation to challenge the bill in court if it was to be passed. There are some who have said, when you're done with your work, Dr. Motshekga, you must take this to the Constitutional Court to assess, because there are chances that this might be challenged in our courts. What's your feeling?
Politicians are political animals, and sometimes to win the hearts and minds of their members, they may decide to go to court even if they have no basis to do so. It's political. But what we have ensured was that wherever we went, we invited AfriForum, and they did attend. But despite that, they went to the United Nations and complained about our process there. We didn't get angry with them because it's their democratic right. But we called them back to Parliament and say, tell us, what is it that you want to see? So we gave them a hearing, they expressed themselves. So when we then finalized the bill, no one, including AfriForum, can say that they were not listened to. So when they go to court, they will have to explain what is the problem, because they have had the opportunity to make a contribution. They did make a contribution, and what would be the problem? Unless if they simply say, we don't want land reform. And if they don't want it, it would mean that they don't want social and political stability, because unless we do something about the land question, that will remain a time bomb, and the security and future of this country would be endangered by our failure to act. So we're acting not against anybody, but acting in the interests of the South African people as a whole, both black and white.
Dr. Motshekga, appreciate your time, and thank you very much for spending this moment with us here on the Newsfeed Late Night and outlining some of those issues. Of course, that is the co-chairperson of the Ad Hoc Committee on Land Expropriation, Dr. Motshekga, and thank you tonight for the conversations on WhatsApp and your comments and your questions coming through the news.